Hello, everyone. This is another episode of the Unisolve question. My guest today is Bhuvana Rai of Mors Tribute Professional Corporation, a tax lawyer, a tax litigator, a really popular person on social media. So I'm really thankful that Bhuvana graced us with her presence today. And thank you so much, Bhuvana, for coming here. Hello, how are you?
I'm doing well. Thanks for having me on here.
You know, I think I want to start with your name because I want to share this with the audience. Just before we started recording, we talked about names, and I got the pronunciation of your name right as far as the stress is concerned. So I stressed the first syllable, Bhuvana, right? And you told me that people pronounce it both ways, but I think the correct way of pronouncing this name is to stress the first syllable, correct?
There's actually no stress. That's the strange trick, is that most languages have stress on some syllable, and in English it can be, the first, second, or third. I think it's usually the second, but in Tamil, at least when it comes to my name, there's no stress, and that is a very challenging thing for speakers of any other language. And so what I try and do is have my preferred pronunciations. And I have two. I have one that's easy for English speakers, and I have one that's easy for Tamil speakers. And those are my preferences, which is interesting given the name debates, right? Because we have so many reasons to want people to pronounce our names correctly in a way that we're familiar with them. And I wonder whether for people who have always had to have dual identities, whether we're stuck with dual names. It's just something that I think about sometimes.
This is deep. This is deep. And I didn't think about multiple identities. I thought about it tangentially before, just being an immigrant myself.
Yeah.
And having a non-Anglo name myself. I thought about multiple identities before. I didn't really thought about it as deeply as you did. So I also want to check something with you to see if we're on the same page about it. Do you think that this is an English language issue also? And do you think this is also an issue of the Anglo world, because the Anglo world was particularly open to immigration in the past? And I think it has the particularly broad diversity of people within its confines, countries such as Canada, US, the UK, Australia. And on the one hand, and on the other hand, it's the English language, which, for example, doesn't have gendered nouns or has ambiguous pronunciations, doesn't have straightforward pronunciation rules. For example, in Russian, pronunciation is unambiguous. You pronounce it the way it's spelled, and there are no two ways to pronounce a word. French, which is another language I know, is slightly more complicated when it comes to pronunciation than Russian, but I think they still have the straightforward pronunciation rules. English, however.
I think in French, they might have an authority. I think there's actually an authority that tells you how to either pronounce or speak the language, which I think is really interesting.
Yes, they have an institute or a committee of some sort, correct? That decides this thing, something like that. But in English, you never know how to pronounce a word that you see for the first time. Even if you're an English speaker, if you see a word for the first time, there is no algorithm about how to pronounce this word. So you just told me something very interesting about your first name. I applied essentially the Anglo logic and the logic that exists in many other languages to your name when I pretended to know that there is such a thing as stress, right? But there is no such thing as stress in the name, in your first name, right?
And it's hard. It's hard because that's actually, I mean, that's not isolated to English. I think it's an Indo-European language thing, I have to assume, because my first language is actually not even within the Indo-European group of languages.
It's Tamil, right?
Yeah, it's a Dravidian language, which is actually just a different language group altogether. And I
Mhm.
don't know whether the lack of emphasis has anything to do with the similarity of the language groups, but this type of linguistic analysis is interesting, right? Because we think about the ways that words have been borrowed and used throughout history. Uh,
Mhm.
and I wonder whether, what you're saying makes a lot of sense, that when English borrows words, we lose the ability to pronounce them in any sort of standard way.
So what standard, remember this debate recently on Twitter about professional name pronouncers? I don't remember what the term was. Professional name speakers at award ceremonies or at graduations. There was this whole debate on Twitter. So what standard should we hold these professional name speakers to in Canada? Should they know how every language family works, or should they just ask the person and then just be really good, maybe they're musical or something, be really good at reproducing what the name owner told them? What standard should we hold them to?
My personal thought is that it always makes sense to just ask someone. And then you won't get it wrong per their preference. And I think that actually is my attitude towards a lot of things, right? If someone needs something, or if there's a way to help someone who has different needs from, say 70% of the population, I think the first step is ask them what they need.
Right, right, right.
So
It's really
similarly,
simple, but it works.
yeah.
Yeah, just ask them. Okay, so we talked a little bit about your origin story already. You told me that your first language is Tamil. Is it your first language or is it your family language?
It's my first language.
So did you speak Tamil before you spoke English?
Yeah. Actually, I studied at an English school, but my parents had forgotten to teach me English. So it was a challenging first year. The rest of the schooling went great, but they just kind of forgot that I might need to know English to go to the school.
Is your family originally from Sri Lanka?
No, from India.
From India? Oh, are there a lot of Tamil speaking people in India?
I think so. I think there's more Tamil speaking people in India than anywhere else.
Oh, wow.
But there's also just so many people in India.
Isn't Sri Lanka the homeland for Tamil people?
Well, I think that I think that Tamil Nadu, which means the land of the Tamils, and is a state in India, might have some disagreement
Oh,
with that. But yeah, I think that certainly for most people in Canada, I think if they're Tamil, they're usually from Sri Lanka, although that's anecdotal for me.
now having grown up with this cultural diversity, with this cultural richness, and having probably thought about identity for much longer than your average Canadian, is this why you chose philosophy as your undergraduate major?
That's a good question. I think probably yes. I found that I liked thinking and I wanted to be able to really dive into an analysis of everything, right? If you ask a philosophy major, they'll probably tell you that, mathematics might think of itself as a very pure field, and think that science is applied mathematics. But in the same way, people who study philosophy might tell you that mathematics is applied philosophy. And I think, regardless of where you fall on that argument, I think philosophy gives you an amazing analytic framework to be able to sift through questions, analyze thoughts, and frankly, practice law. So I find that at least I'm using the same framework of thinking throughout, and I can go back to those principles even if I don't necessarily read a lot of philosophy anymore.
Mhm. Well, your explanation right now was really pleasing to my ear because I enjoy well-structured analytical presentation of thought. well-articulated presentation of thought. And that's exactly what I heard right now. So I attribute part of that to your philosophy training, as you explained just now. Now, was law on the horizon when you chose philosophy, or you had no idea that you would end up being a lawyer?
I didn't really have a clue. And honestly, I was really into science in high school. So I didn't think that I would be a lawyer. I went into philosophy because it was what I was interested in. And luckily, 18-year-olds, I guess, don't think necessarily about long-term careers. And I really just wanted to study it because I was interested in it. But I was too interested in it. I finished most of the core courses really early. And in my second year, I was kind of thinking, okay, I need to figure out what I'm doing next year. Do I want to do a dual degree, or do I want to go do something else like a law degree? And so I thought about it and decided that, in my head, lawyers were paid to think, whereas philosophers struggle to get the jobs where they got paid to think. So I thought, okay, great, I will go to law school. I know that writing is an important skill, analysis is an important skill. And I applied to law school. I was lucky enough to get in at the University of Toronto. And so I decided to go on that adventure.
You finished your undergrad in 3 years.
3.5. I had to do it at the same time as law school. So that was not the best decision.
That's right. So essentially you started your law school in 2011, and you started your undergrad in 2009. So in your third year of undergrad, you started your law school, correct?
Yeah, that's right.
And you say that it was not a great decision, but on the other hand, I can see how many honors you received in your undergrad. And also the amazing thing is your undergrad was in Calgary, but your law school was in Toronto.
That's right.
It's like a long distance relationship or something. How did you make that work?
Summer courses and a couple of courses through universities to fulfill my requirements for language and so on. I'd done all my philosophy courses, but there were other requirements for my degree that I had to complete.
I think you are the right person to ask this question. Do you think our education is too long? Do you think they make us spend too many years in school and we can cover the same ground in 1 year that we cover in 3? I'm talking about law school in particular, but I'm sure that the undergrad would follow the same principles.
I'm not sure how you feel about it. I think we make too much of a confluence between degrees which are really for the purpose of scholastic and academic inquiry, and we confuse or associate them with degrees which are practical and intended for a specific profession. I think, given that, I wonder whether it makes sense to qualify as a lawyer going through something like a trade school, which is about half of what we learn, or maybe even less in law school, and then to learn legal theory, which is also interesting and certainly something that I love thinking about. But I wonder whether it makes sense to have legal theory be separate and maybe even an add-on to the sort of essential trade aspects of law. I don't know if that really answers that question, but I wonder whether it makes sense to separate those, because I think the trade school could, and I call it that, but really the part of law that teaches you the practical essentials of how to run a business, how to be a lawyer, how to talk to clients, how to make clients feel comfortable, how to practice law, where to find the rules, where to find the forms. All of those things, I think, are just so different from the legal theory that we often learn in school, which is also valuable. But I just think that maybe we should separate them and then think about how much of each we want.
Looking at your resume, I'm looking at your LinkedIn profile. You didn't send me a resume for the audience. I see that you really have a penchant for doing two things at the same time. So, for example, after you graduated from the JD program at U of T Law School, the following year you started an LLM program at Osgood.
So that was actually, I didn't necessarily decide to do that so much as I'm very grateful for this, but I was railroaded into that by Justice Hogan at the tax court when I was a clerk, because he was so invested in making sure that we all had bright futures and used our degrees wisely and pursued our interests in tax law appropriately. And like, he told us to do a tax law degree. And I said, okay, well, I guess I will apply next year because the deadline's probably passed. And he followed up the next day with like, hey, so what if you ask them if you could go late? You know, I just found all of this. And I was like, well, if he's done all this research, I have to apply now. It was the best decision. That LLM program taught me so much about tax law and tax practice, and really crystallized a lot of those concepts that, you know, you sort of interact with through law school. So I'm really grateful I did it, but that was a happy accident.
Right. And this happy accident occurred at the same time as you were completing your judicial clerkship at the Tax Court of Canada. So you completed your LLM and the clerkship at the same time. The clerkship was done in 1 year and the LLM took 2 years.
Yeah, it's a distance program. And the tax court was really great about letting clerks go and, you know, take that leave when they needed to while still fulfilling those articling requirements.
You are joining, or you have joined, a very long list of this show's guests who completed a judicial clerkship. And I'm really curious. So I talked to a lot of people who clerked at the Supreme Court of Canada. I'm really curious what clerking at the tax court is like. So I'd like to compare tax court with the Supreme Court, or with a provincial court of appeal.
Yeah, I don't know if I'm the first tax court former clerk to appear on this, but I'll tell you a little bit about how it's different. You don't shadow one judge. You speak to all of the judges, and you'll ideally do assignments that are with a number of different judges. So you get a really well-balanced picture, or you hope you do. Sometimes, you know, a case is so large that you will just be assigned to it, and you might actually miss out on the opportunity to work with other judges. But on the other hand, you get to know one file and one judge really well. The idea is that, you know, that way you're not just learning from one person or thinking just about one person, because in tax court, you need to do two very different things. You need to know the law that deals only with taxes, but then you need to understand how to litigate tax cases, which is also different from normal litigation. So, you know, some people who are appointed to the tax court are appointed and they've been tax planners their whole lives. Some people have been tax litigators, and that's, I think, happening more and more these days. But because of that, you know, you might actually need multiple perspectives and multiple people to work with. And I'm really grateful that I got to work with so many different and amazing people at the tax court.
Right. So really interested in this point that you made, that tax litigation or litigation in tax court is really different from other types of litigation. Well, first of all, let's define the scope of tax litigation. Tax litigation involves more than just proceedings in the tax court of Canada. I think it starts with a notice of objection, if I'm not mistaken, correct?
So I would personally classify that as a tax dispute, but the litigation stage is when you file a notice of appeal or an application for judicial review, or in rare cases, you file a claim with the provincial court, but that's actually quite rare.
My claim to superficial knowledge of tax litigation is very simple. It's based on my experience as an articling student. I did some tax litigation as an articling student. I even got a remission order, by the way, as an articling student, just throwing it out there. But also the interview that I did with Michael Lubetsky of Davies, I learned quite a bit about tax litigation there. So pardon me if I sound amateurish or ignorant. I only have fairly superficial or outdated knowledge of tax litigation. I don't do it anymore. But when you say that there are two stages, in your opinion, the tax dispute stage and the tax litigation stage, do you mean that there is no connection between these two stages, or surely you plan for litigation? It's like you're preparing for the worst when you are in the notice of objection stage, or when you're negotiating with the CRA?
Yeah, I mean, it is similar and it isn't. In the notice of objection stage, if you're in appeals, or even during the audit when you might be speaking to and negotiating with an auditor, you focus on the tax side of things, primarily because you're not dealing with lawyers on the other side. You're focusing on the facts and you're focusing a little bit on the law, but you're primarily just focusing on making sure that the facts of your case align with the CRA's audit manual. Because the CRA audit manual isn't law, but that's what the CRA is going to use. And its internal guidance is going to be primarily what the CRA auditors and objections departments use when they're evaluating your claim. You might speak to the law, right? You might make representations, and they might even be very similar to the representations that you'll make later on. But at least personally, I don't think that that is the crux of a matter that is before audit or in objections. And there's also a couple of different paths you can take, right? Because you don't have to go through objections and wait for them to resolve them within 3 years, because after 90 days, you can just file a notice of appeal to the tax court. On the other side, you don't have to have gone through objections to have some sort of litigation with the tax court, within the tax realm. You need it for the tax court because you need to file a notice of objection and then proceed that way to the tax court. But if you need something that can't be dealt with by the tax court, if you're looking for some sort of equitable relief, then you might start at the federal court, right? So you might be in the middle of an audit and have an application before the federal court. You might have a collections issue, which will almost never touch tax court, but will be heard by the federal court. So there's some similarities, but there's also some differences. I think for me, the primary difference is, even when you're talking about litigation in front of the tax court, is that, I think people who are litigators, we will all often assume that different courts have similar rules. And that's true in some ways, but the truth is that the tax court has its own specific set of rules, and they interact with substantive tax. So I think it's helpful to have that background if you're going to litigate in tax court. The other key thing, though, is that, you are, I think it's unexpected for most people that tax court shifts the burden of proof. So the appellant, the taxpayer, is required to show that the minister's assumptions are wrong. And that one of the Supreme Court dissents on this called it demolishing the minister's assumptions of fact. So the onus is on the taxpayer, the appellant, to show that the minister's assessment is wrong. And I think that can be a little counterintuitive for a self-represented taxpayer who, generally expects that the Crown should defend their assessment. But the truth is that you need to show that it's false. So the burden of proof being shifted is, I think, a little bit strange to people that don't practice in tax court.
It's like the mirror image of a criminal case.
Exactly, yeah.
You still are suing the government, or the government is suing your client, but the burden of proof is flipped. And I hope that they are not holding the taxpayer to the same burden of proof that they're holding the government to in criminal cases.
Not beyond all reasonable doubt. It is the civil.
So you just made a very interesting point, and there is this theme in our law that the not always, not in criminal law, for example, but especially in civil matters, that the government is presumed to be rational and to act in good faith and to do the right thing. When you ask an ordinary person what they think about the government, and if they can make that presumption, I don't think that an ordinary person will always agree with that. But is there some kind of, so you talked about applications to the federal court, and I assume you are talking about some sort of interlocutory applications for judicial review, right? That have to do with some steps in the dispute.
Or anything equitable. Right,
Anything equitable. Okay, so the tax court does not have an equitable jurisdiction whatsoever, right? But the federal court does by virtue of the Federal Court Act or something like that.
Yes, so the federal court can't hear tax matters. That's the exclusive jurisdiction of the tax court.
Right.
The tax court isn't really permitted to give equitable relief. And sometimes that actually just means that, how the taxpayers have a gap where, the federal court will say, no, go to the tax court because it deals with the correctness of an assessment. And the tax court will say, well, this seems like an equitable remedy. To a certain extent, we do have a little bit of tension there, and we do have a bit of a gap when a case has both equitable and correctness components to it.
Right. And of course, appeals from the Tax Court of Canada lie to the Federal Court of Appeal of Canada.
Mhm.
So you might find someone like a former guest or one of the guests of the show, Justice Stratus, on the panel hearing an appeal from a tax matter, for example.
Yes.
Yeah, that'd be great. I mean, I wish I could argue an appeal before Justice Stratus and the tax appeal at that. But the question here, with all these presumptions in favor of the government, in favor of the voice of the people, so to speak, we also presume that our government is free and democratic. We do know that sometimes governments act in bad faith. We do know that sometimes governments cause serious harm. And when that happens in tax matters, when the CRA does it, are there any civil remedies against the CRA, or is it a dead end, basically?
A lot of taxpayers have tried to show that the CRA wrongfully assessed them and caused them all these issues. It's been rarely, if ever, successful. And if successful, it's been very, very limited. The CRA really, really, truly needs to have done something so far off, what you would expect that you could even think about bringing an action. I mean, the reality is, right, people are emotionally invested in not being seen as cheating tax. And that can make tax a really personal thing for them. But the reality is that this is ultimately about money. It's not about civil liberty. It's not about whether or not you're going to be in jail. It's not about, whether you get to see your kids. At the end of the day, tax law is about money. And the cases that are being disputed are about money. Taxpayers rarely feel that way, especially when it's an individual, because, and I think this is correct, they feel that they're being judged and harshly and wrongly when they feel accused of something that they didn't do. And I think that's a real, emotional part that we don't really pay attention to in tax. But, the theory behind having all of these government rights, if you want to call them that, in tax is that it is just money. You don't have the same sorts of procedural ideals necessarily as you would when you were discussing someone's freedom or their ability to move around the country or have privacy or something that really truly seems personal. The other sort of aspect of it, though, is just the Herculean task of administering the tax code, right? If, tax affects everyone, even family law doesn't have as many, relationships with someone's personal and day-to-day life as tax law does. Given how many people's returns the CRA has to assess and how many of them will get audited, Because, the government does spend a lot of money on the audit side of tax without necessarily spending the same on the tax court or the appeals branches, which is part of why the wait times get longer. But going back to the audit branch of the CRA, there's only going to be so many cases that they can get through. And if they had the burden of proof in every case, given that the taxpayer knows their own affairs best, it would be really difficult for the government to try and ensure any sort of compliance with the tax code. So it's sort of like there's no perfect answer. You just kind of have to do the best with what you have as a government. And that's the policy choice that Canada has made, is that, we accept that taxpayers will have to go to court and disprove the government instead of expecting the government to prove their case.
Right. And when you talk about this all being about money and the tax proceedings being about money, you of course are talking about tax proceedings not involving criminal penalties.
Criminal, but even, in other civil disputes, right? Think about family court. These are really personal issues about,
right, custody or access,
yeah.
children.
There are a lot of sort of more personal torts, if I can characterize them that way. Things like injury to your person or privacy, anything for which you would normally seek equitable relief. In short, it doesn't really interact with tax law, or certainly it doesn't interact with the correctness of an assessment.
Right. So the criminal offenses associated with the Income Tax Act.
Yeah.
Are they defined in the Income Tax Act, or are they defined in the Criminal Code?
They're primarily defined in the Income Tax Act, although there are parts of the Criminal Code that I'm sure you can add on. And that's a really interesting area as well, right? Because there's such broad audit powers of the CRA, because it's presumed to be a civil matter. But where CRA refers that or believes that there may be a criminal matter involved, the former taxpayer, now accused, has different rights in terms of privacy and whether or not the CRA can just access all their property without a warrant. So that's a really interesting line, and something that cases have started to address in the past decade or so.
It's almost like if someone is to cheat the CRA, they should cross the line and cheat the CRA all the way up to the criminal liability level, because then procedurally they will be at the greater advantage. No, not suggesting that people do that, just being a nerd.
Just to be clear, you will be assessed the tax still. Like, you will still get all the taxes and the penalties, and then you might also get thrown in jail.
Right.
So this tax lawyer thinks that you should not commit criminal.
Okay.
It's to not commit crimes.
Okay, I won't. Now, you talked about the special standing that government has in tax cases and tax proceedings. You talked about the shifted burden, evidentiary burden, the evidentiary burden on the taxpayer. You talked about the essential lack of civil remedies against the CRA, or really rare opportunity to exercise such remedies. Now, with all this special treatment, why would CRA settle? Why do they settle?
Yeah, well, a lot of the time they don't, but I think it goes back to some other really special things about tax, right? So firstly, in tax, the government can't just accept, half the money on the basis that we'll just cut the difference. There has to be a principled basis for each settlement. So they have to actually have a legal reason to settle in a particular way, which is unique, I think, but they would settle, I think. Ideally, they would settle when they can't make a case and when the taxpayer seems to be right. Functionally, I think the whole purpose of the adversarial process is, in a way, to find out what the truth is. And given that the taxpayer has such a heavy burden, It's been my experience that sometimes justice lawyers will think, okay, well, just come to court and prove it. Sometimes they think about a file early, but given the large caseloads and the proportion of funding that is given to the appeals and litigation stages as opposed to the audit stage, I'm not sure that there's really a capacity to review cases early enough to settle them.
Right. Okay, so I'm looking again at your LinkedIn profile. I keep coming back to your LinkedIn profile. A very good profile, by the way.
Thank you.
And I see that your career path was really high bar, high standard, high, strong brand career path. So you clerked at the Tax Court of Canada. Then you practiced law with the DOJ for almost 2 years in their tax litigation department. And then you practiced law as a tax associate at BLG for more than 2 years. And then you practiced law again in the tax department of Ernst & Young. I don't know if they still refer to them as Ernst & Young or just EY.
It's the affiliated law firm, but I think they might even just call themselves EY now. I'm not sure.
Yeah. So this is quite a, I would say, a blue chip, high brand, strong brand, big brand path. And then at the end of this path, you decided to create your own strong brand.
Well, I'm working on
it. Yeah, and I think it's a great name, Mors Tribute. I don't know if you got any marketing advice or brand and identity advice, or if it's all you. We can talk about it. So let's talk a little bit about, we don't have much time left, unfortunately, but please tell us about starting your own firm after all these big brand experiences. How did that happen?
Well, I guess I always thought that I might want to consider having my own law firm because I like the business of law. I think that not everyone really cares about or wants to engage in the business aspect of law, but I like it. I care about it. I think it's a good thing to think about. So, I'm really grateful that I got to do all of these amazing things with some of the brightest people I've ever met, because I've gotten to learn a lot of different skills from them. At the Department of Justice, I was on my feet constantly. I was litigating constantly, and that was wonderful for giving me a really good sense of court procedure and the knowledge of how to take a file from beginning to end. BLG was a fantastic way to learn about the world of, private corporations, estate planning, not as much tax litigation as I would have liked, but it was a really great way to learn about the planning and implementation side of tax, which is really important as well. And then when I went to Ernst & Young, I wanted to, or EY Law, which is, I guess, where I was primarily working. I wanted to move to Toronto, and I also wanted to work, with sort of the biggest names in tax. You talk about being nerdy, and that's essentially what I wanted to do, is to work with all these people I'd heard of, and to see what that experience is like, because at a captive law firm, you get clients handed to you by the accounting firm. You don't really have to do a lot of looking around for clients. But at the same time, you have to be far more cost conscious because an accounting firm just has different standards. It isn't designed to make life easy for lawyers. So for example, the partners do not have a dedicated admin assistant, which I think is crazy for a lawyer that is working in Bay Street to hear about. So one thing that I got from that experience is just, I hand wrote my invoices to clients. So I know how to do that. I hand did my conflict checks. So I know how to do that. I created my own ledgers because I had to. And so I know how to do that. So it gave me a lot of the skills that I needed to run my own firm because I wasn't relying on administrative support. And while that was frustrating while I was there, it actually really gave me a leg up when I, had to come up with a retainer letter, and I could just think about, okay, well, what have I liked? What have I not liked? And I just got to work with so many really smart people and feel that, I could be part of the tax community and I could continue to add value and really be a tax lawyer by myself. Because I think whenever you're thinking about going into practice on your own, you wonder, okay, am I good enough? Am I going to be able to help clients? Am I going to be able to take a file from beginning to end? And it was nice to know that maybe I could, or at least it was worth trying.
And you definitely could. So you've started your firm in April, if I'm not mistaken.
Yes, that's right.
Did you have any book of business when you started the firm, or did you start from scratch? How was it?
So I started from scratch. The way that tax practices at most firms work is that the tax group is supporting the other groups. You don't really have that much of a dedicated book of business within the tax group. So I was really nervous, and it held me back for a long time. But one nice thing is that sometimes clients do want to follow you. And when you look at EY, it's an institutional, or it's a large institution with lots of institutional clients. So you don't really expect to take too many files with you. But I had a couple of former clients reach out about different matters or personal matters. And so that makes you feel good because you think, okay, this is a vote of confidence. But there's also just a huge mid-market in the tax law area that's not being served. There are far too many self-represented litigants who go to the tax court. And I say far too many because they are firstly facing the Department of Justice, which has a lawyer. It has, processes for dealing with and making representations on a tax matter. And then, it also takes up a lot of court time for when you have self-represented litigants that need additional court time or additional procedural concessions. So I think, as the tax bar grows, we need to think about how we can access this sort of middle market that doesn't need to hire a Bay Street law firm just to handle a relatively small tax matter, but doesn't want to represent themselves going to tax court.
Fascinating. Do you provide tax planning services as well as tax litigation?
Yes, but only in certain areas. I focus more on the tax litigation side of things, primarily because I think, you should be put to your highest and best use. And I think, I'm better at tax litigation than I am at anything else.
Are you interested in cryptocurrency cases?
Of course. I mean, I think it's a changing area of both law and economics. And so that is actually, I think, something that we're all going to have to deal with a little bit in future.
That's right. That's right. I completely agree with you. So explain the name of your firm. Mors Tribute are not your senior partners, obviously.
No, they're not. It's a bit of a nerdy joke again. I like to joke that my practice is death and taxes because I do estate planning and tax law. So I translated those words into Latin, and that's how I got Mors Tribute.
Oh, Morse, right? Morse. I see. So this is really nerdy.
Very nerdy, yeah.
But I really like it. I really like it. So this is great. So just in the remaining several minutes, please tell us about your big plans for your firm. Tell us what your typical client profile is like. Tell us what your ideal client profile looks like, and tell us what it's all going to be like in 20 years from now.
Sounds good. So my hope and dream is to make, frankly, the biggest, most well-respected tax law firm in the country. That's a long shot, but it'll take a lot of work and it'll take a lot of dedication. But that's what I want to do. I want to try and provide really high quality legal services. Tax law, like personal injury, has a lot of money in it. So you can often have firms that are not law firms, they're referral services firms, because that's where they make the bulk of their money. And I thought early on that I wanted nothing to do with that, because I want to focus on giving high quality legal advice. And I want to refer work when it goes to the best person. And I want people to refer me work if they think I'll be the best person for the job. So I made the decision not to accept and not to pay referral fees, but we'll see how that goes in the future, right? Because it's actually very much an industry standard for small tax law firms. Given the commitment to providing the best quality legal services for a reasonable, appropriate price, I think that that is the best marketing that you can have, is satisfied clients, satisfied professionals. I don't have a typical client yet, because I've had so many different types of cases and so many different types of requests so far. But my ideal client is actually other firms. I think that, you know, there's a lot of room for both accountants and for lawyers to be able to call a tax lawyer and just have them on retainer to give answers to tax questions on whatever files they're working on, and to just provide legal advice as needed. I don't think that most law firms, especially specialty ones, need to have a tax lawyer on staff, but they often should get tax advice. And I think that that is my ideal client, because, you know, if a question is coming from other professionals, it means it's a hard question. It means I actually have to think about it. It means I have to research it. So that's my ideal client, and my ideal question is just, you know, you wonder, how does this work? Or I wonder what to do about this. And you just get to call me and, you know, get 0.2 of an hour billed to you, instead of trying to learn tax law on the side of your practice.
Bhuvana, in 10 or 15 years, or maybe sooner, when you do have the biggest tax law firm in Canada, I'm going to be very proud of this interview. Thank you so much, Bhuvana. It was a great pleasure. I really appreciate your visit to our show. Thank you so much.
Thank you for having me.